Hi everybody, welcome. I'm Ilana Fima. Thank you very much for coming along tonight to UCL, and thank you in particular to our speakers, and thank you also in particular to Nina. So we were on a call with Nina at one point, and she sort of said, there's this REULA Act, and we should really be thinking about it. And there are all these interesting judgments coming out. There's tune-in, and there's the e-accounting judgment. And I tried to look very clever at that point and realised I didn't know as much about this as I should, but I think it is something that we should all know about. And I'm very grateful to Nina for making that suggestion, and I'm very grateful to our speakers for coming along and enlightening us, and also to Richard for agreeing to chair. So thank you and welcome.
So, thank you, Ilana, and welcome, everybody. I, in common with a number of other lawyers in the room, I suspect, recently received a publication which was entitled The Second Supplement to the 8th edition of Benyon et al. On Statutory Interpretation. And when I opened this volume, I discovered that the entire subject of this supplement was the REULA Act. So I think that's some measure of the potential impact of this piece of legislation is going to have on the law, that there's an entire supplement to a book on statutory interpretation devoted to it. To assist us in understanding the potential impact of this piece of legislation, we have 4 distinguished speakers for you this evening. First up will be Dr. Ruth Fox, who is immediately to my right, who is director of the Hansard Society, and she's going to tell us a little bit about how we come to have this Act of Parliament and how it ended up in its final shape. Second, we have His Honour Judge James Tyndall to my extreme left, who is a specialist civil circuit judge in Birmingham, if I remember correctly. Thank you. Yes. And he's going to be talking about the general architecture of the legislation and its key provisions. One small point to note about that, which I will save Jim a minute or two explaining, is he's going to be telling us a lot about Section 6, which is a very important section of the Act, but it's not in force yet, at least according to Westlaw when I checked this afternoon. Westlaw is not 100% reliable on these things, although it's usually reliable. I think it's accurate in this case, but just bear that in mind when we speak about Section 6. Then, thirdly, we've got Nina O'Sullivan, who is to my immediate left from Mishcons, who's going to be talking about the substantive implications for IP law. And then lastly, we have Professor Philip Johnson to my extreme right, who's Professor of IP law at Cardiff, and he's going to be talking about various miscellaneous aspects as far as IP law is concerned, including remedies, the enforcement directive, and so on. We were hoping to have a 5th speaker from UK IPO, but unfortunately they are so busy with all their various projects at the moment that they were unable to make anybody available for this event, which is quite understandable. So, with that brief introduction, I will hand over immediately to our first speaker, Dr. Ruth Fox.
Thank you, Richard, and good evening, everyone. Thank you for the invitation to speak tonight. I should perhaps explain, because I'm probably one of the few people in the room that's either not a lawyer or not studying law, not otherwise involved in legal work. The organisation I'm director of, the Hansard Society, is a parliamentary research think tank, education society, founded by Winston Churchill and Clement Attlee. We've been going for 80 years. And the focus of our work is to develop proposals, ideas for reform of Parliament so that it is a more effective institution. So you can imagine we're never much short of work as things go. And the reason I'm here is because in that capacity, I've done work over 15 years on parliamentary scrutiny of delegated legislation, of how parliamentarians scrutinise statutory instruments, or rather how they don't really scrutinise them and how it could be much better, and developing proposals for reform of that system of scrutiny. So the retained EU law bill, when it first emerged, was first laid in Parliament, was a significant piece of work for us because it had very significant powers that would be delegated to ministers to make regulations to reform retained EU law. And if you remember, in the first guise of the bill, the plan was that ministers, Jacob Rees-Mogg, planned to essentially revoke all retained EU law by the 31st of December last year, unless ministers chose to save it, which was perhaps one of the most bonkers ideas we've ever heard in Parliament in recent years, and there have been a few to choose from. We are on the record, aren't we? So I became involved because we hosted the first ever public event on this bill within days of it coming out to talk about the delegated powers and the implications of that revocation process. And we had guests Lord Anderson of Ipswich, leading crossbench peer and barrister, and Sir Jonathan Jones, former head of the Government Legal Service. And that set the tone for a lot of what followed, particularly in the House of Lords, who take more interest than MPs do in delegated powers in bills. Now, they then developed a much bigger campaign in civil society involving the trade unions, the environmental movement and so on, to raise awareness of the problems with the powers in the bill and the implications of revocation. And the government eventually saw sense last summer and decided that no, they wouldn't revoke the entirety of REULA. What they would do was set out what could be revoked in a schedule, and that would be revoked at the end of last year, and then they would work up a programme of reform of retained EU law that had otherwise been saved. And it's that I want to talk about tonight, just the process, the parliamentary process of this and the political process that is going to emerge around the REULA reform programme, and just to highlight some of the issues and problems that are going to come up because of the inadequacies of the scrutiny process for delegated legislation. So it is a huge exercise. The government's already revoked sort of about 600 pieces of retained EU law listed in this Schedule 1 of the Act, and it's already laid 20-odd statutory instruments before Parliament to make changes to other areas of retained EU law. But essentially, ministers have got a choice about how they use the powers in the Act: to revoke and not replace regulations, to revoke and replace them with something similar, to revoke and replace them with something completely different, or to retain them. And it's about, the government estimates, or certainly estimated as of yesterday, when I last looked at the retained EU law dashboard that the government has produced, the government's reviewed about 23% of retained EU law to date and has made decisions about what it wants to do. Now, the thing to bear in mind about this is it is a process that is unevenly distributed across Whitehall. Some government departments, particularly DEFRA, the Department of the Environment, have a huge burden of work to do. Other departments have very, very little. One of the consequences of that will be on Parliament, because an uneven distribution of work in departments means an uneven distribution of work for parliamentary departmental select committees. So, the departmental select committee that covers the environment will have an awful lot more work to do than some of the other smaller departments, and that's going to have consequences for how much attention and focus the departmental select committees can place on scrutinising retained EU law reform, and consequently how much time and effort they can spend on other things. They have to prioritise. If I want you to take away a headline message today, it is that once a regulation, a REULA reform regulation is laid before Parliament, it's generally too late to do anything with it at that point. Parliamentarians can't amend statutory instruments. It's a take it or leave it proposition for one or both houses, and MPs last rejected an instrument in 1979. So think about the politics of that in an election year. If an instrument is found to be legally defective or drafted wrongly in some way, then the government may withdraw it and replace it. But if it's got a policy or operational problem with it, the government may not do so and may persist with the instrument as is. The parliamentary scrutiny process and engagement process is, particularly by MPs, is as bad as you may have heard. And if you want to secure changes to rules, so if you are either a lawyer or if you're a campaign organisation, if you're a regulator and you're wanting to get changes to retained EU law before the instrument is laid, it's essential that the work is done upstream in terms of consultation with Whitehall, because once it reaches Parliament, it really is largely too late. Just wanted to run over a few scrutiny features of the Act that will come into play over the coming years, regardless of what policy sector you're talking about. So the key scrutiny feature is that the majority of instruments will be subject to what's called the negative scrutiny procedure in Parliament, which essentially means it's the default procedure for the consideration of statutory instruments, and it essentially means that Parliament is not required to actively consent to the instruments. It's deemed to have consented unless MPs or peers pass a motion, which becomes a resolution of the House, to reject the instrument. And as I said, they last did that in the Commons in 1979. In fact, only 7 instruments subject to the negative procedure have ever been rejected since 1950. So it is a very, very rare thing. It's a politically explosive device, particularly for the House of Lords, if they were to reject something and the House of Commons was content with it. If some of the powers are used to amend an Act, the affirmative scrutiny procedure will apply under the terms of some of the powers in the REULA Act, and that is for the more substantial and important pieces of legislation. And essentially, that regulation, that statutory instrument, cannot be made into law unless and until one or both houses have actively debated and approved it. But the debating and approval process is really quite minimal. Debates rarely last more than half an hour. At a maximum, they can be 90 minutes in the House of Commons. It's done by a committee of 16, 17 MPs, most of whom might have been told only a couple of days before that they're going to be on the committee, most of whom will have no technical understanding or know-how about very technical instruments that they may be looking at, and if they know anything about it, the issue, about the subject, it's unlikely the whips will appoint them to the committees. So the level of scrutiny, I'm afraid, is quite low. And Parliament's only ever rejected 9 affirmative instruments that they've actively debated and approved since the 1950s. The Act does make provision for certain powers, 3 powers: the power to restate rule, the power to restate assimilated law, which is this new category of what we now call rule since the end of the last year, or the power to restate some set of EU rights, and some uses of the power to replace or revoke secondary rule. It subjects those to an additional layer of scrutiny called sifting, which is also in the EU Withdrawal Act and the EU Future Relationship Act. And this is how parliamentarians try to essentially assert a little bit more scrutiny, a little bit more control over what the government is doing. But in practice, all that means is that the government's proposing under those powers to lay an instrument subject to the negative scrutiny procedure, they have to do so first as a proposal. And a sifting committee in each house will consider whether it should be upgraded from the negative to the affirmative procedure. And if it is upgraded to the affirmative procedure, then it will have to be debated. That is the sole consequence of this sifting process. So it gives a little bit more handle for parliamentarians over these regulations, but not very much. And in practice, does it make an awful lot of difference? Not very much at all. It's a fairly weak form of scrutiny. There's a third element to the REULA Act, one that I think is something that the government inserted for cosmetic purposes, and they won't actually use it in practice very much, but it's worth just knowing about, and that's that it extends the scope of legislative reform orders to retained EU law. So the Legislative and Regulatory Reform Act of 2006 was provided powers for ministers to remove legislative and regulatory burdens through what are called these legislative reform orders. And at the time, they were the broadest powers that had ever been sought by ministers. At the time, the Legislative and Regulatory Reform Act, was known as the Abolish Parliament Bill, so far-reaching were its powers. And what the government has done with the REULA Act is basically extend some of the provisions and amend the Legislative and Regulatory Reform Act so that they can use legislative reform orders in order to undertake this deregulatory exercise. Now, basically what that means is that if ministers want to use powers under those provisions, they will have to subject them to public consultation. So there will be an opportunity for organisations to have a say at that stage. The committee will have longer to scrutinise the instruments than is the norm, and it could be upgraded again from the negative to the affirmative and the affirmative to the super-affirmative procedure. All it means is more time and a little bit more scrutiny, but in practice it doesn't really empower MPs or peers to significantly change the instruments because it doesn't grant the power of amendment. Although what it does provide is the opportunity in extreme circumstances for a parliamentary committee to recommend that the House should veto the regulation. But in practice, that's only ever happened once. The problem with legislative reform orders is they can take 12 to 18 months. So why would you bother with them rather than undertake the change you want via primary legislation, which you can do more quickly? So that is the reason why I think it's a bit of a sop. And the final thing to look out for is statutory reporting to Parliament. One of the things that was inserted into the Act, and it came about in part because of a proposal I made to the Public Bill Committee and the Secondary Legislation Scrutiny Committee in the House of Lords when I gave evidence to it with Sir Jonathan Jones, the former head of the Government Legal Service, is that Parliament needed a little bit of bite to monitor what the government was doing. The government's big concern was that in trying to review and reform retained EU law, they were up against bureaucratic inertia in Whitehall. And unless they put deadlines in, the work wouldn't get done. Now, their approach to it was to say, we will revoke everything unless we choose to save it, and that will put the pressure on Whitehall to get the work done, do the research, and figure out what it is we want to save and what we don't. The scale of that exercise was far too big. So what people like myself and others suggested was that in order to put those sort of political knives into the process, if you like, to get the pressure on the civil service to do the work to certain deadlines, you could put parliamentary statutory reporting into the system. So they've inserted into it a statutory obligation to publish and lay before Parliament 6 status or planning reports at 6 monthly intervals. Now, the first one, ironically, was due, the deadline for publication was today. And I was rather hoping they might have published it last week so I could have looked at it and told you something about it. But it was published this afternoon when I was in the Hansard Society board meeting. So I have seen the link, but I'm afraid I haven't had an opportunity to have a look at it. But I did do a quick word search on things like copyright and trademarks, and there didn't look to be anything particularly interesting at this stage. But that is something to keep an eye on. Every 6 months, statutory reporting deadlines. The next one will be 23rd of July. But think about this, it's a general election year. We don't know when the election will be. We have to think about the timescale for the dissolution of Parliament. We also have to think about the timescales for parliamentary recesses. Some of these timings over the next few years through to July 2026, these 6 monthly intervals, will hit in those recess periods, will hit possibly during dissolution of Parliament for an election. So the extent to which there is going to be the kind of political focus there ought to be on this issue and on what the government is proposing is not likely to be there unless organisations outside exert their influence and keep it under a microscope. But it is potentially a useful tool to look at. The difficulty is those reports will be scrutinised by the European Scrutiny Committee in the House of Commons, which is chaired by Sir Bill Cash. Another thing for you to reflect upon and keep an eye on, that is not a functioning cross-party select committee over the last couple of years. Labour has barely attended it. So in terms of having scrutiny of what the government is doing, it's really only partial. Even when the Secretary of State for Trade has turned up, Kemi Badenoch, no Labour MPs attended that question and answer session, which is pretty extraordinary. So one of the things we're sort of keeping an eye on and keep raising in Parliament is that there has to be, the opposition parties have to turn up and they have to subject ministers to questioning and accountability over the decisions that they're going to take, because this programme of retained EU law reform could be enormous in its implications across a whole number of sectors and could could be advantageous, but could also cause problems. But the political focus and will isn't there at the moment, and therefore it's imperative that outside organisations and individuals like yourselves keep an eye on it and can raise it at the opportune time, whether that's through legal or political means. Thank you.
So, thank you, Ruth, for that illuminating background to some of what's going to be hitting us. And that then takes us to our next speaker, Jim.
Good evening. Thank you very much for having me. As will rapidly become apparent, it's a real privilege for me to be here because I'm not really an intellectual property lawyer at all. I'm an EU lawyer by background, and so in some ways this lecture is an opportunity for me to spend 5 minutes going down memory lane about some of the cases that I used to deal with, because I won't be allowed to talk about them again because they'll just be purely historical and no one will be interested. I hope you're slightly interested, because they are important to understand this very important new act, because it helps us, for us to understand what it does, we need to understand what it replaces. I've called it Into Uncharted Waters, and that will hopefully become clear at the end, but I do need to start with the incoming tide. And back in 1974, Lord Denning, who was always slightly ahead of the game, even if he was out on his own sometimes in every single way, said, when we come to matters with a European element, the treaty is like an incoming tide. It flows into the estuaries and up the rivers. It cannot be held back. Very emotive language, and perhaps anticipating some of the political debates that there would rage over the coming decades. By the 80s, the courts and the English courts' approach to European community, as it then was, law, was quite cautious. It was seen to be an extension of established statutory interpretation principles of interpreting domestic legislation in accordance with international obligations. The sort of thing you sometimes see in relation to the Convention on the Rights of the Child and things like that. It's quite a soft form of interpretation. But in 1989, there were 3 or 4 House of Lords cases all on top of each other. And Pickstone and Freeman's was the first that really pushed statutory interpretation beyond what we would previously have recognised in terms of effectively an exercise we now are familiar with from the Human Rights Act and so on, stretching language, compressing language, skipping over the meaning of words and so on. But that was the first time the Lords had done something like that. Factortame in 1990 is credited with being the case that woke up the Eurosceptic wing of British politics. It was said, I think, at the time, a few years later, that until Factortame, everyone just assumed that this was an economic community and it didn't really have serious legal implications. Factortame involved the House of Lords suspending an Act of Parliament. The sort of thing that we didn't think that English judges could do. It's true that they only did it after the European Court of Justice had told them that they had to, effectively, but they still did it. And Lord Bridge was, in his judgment, actually went on about the fact that this was said to be a controversial situation, and the people that were sounding off about it, he didn't put it quite like this, but the gist of it was, people who were sounding off about it clearly hadn't understood what the European economic community was about in the first place. And into the 90s and into the 2000s, we then had English courts adopting with a degree of enthusiasm this new concept of purposive interpretation based upon the European Court of Justice case called Marleasing, to the extent that in an intellectual property case called Intel, Lord Justice Jacob effectively said, I don't know why Parliament, again, paraphrasing, I don't know why Parliament bothers to amend acts. What's the point? if the directive changes, the meaning of the Act will inevitably change as a consequence. You don't need to amend the Act, it just causes trouble. So effectively was the extent to which that power of statutory interpretation had been taken. And then the Miller case, that you may remember, the Article 50 case from a few years ago, and that described Section 2 of the European Communities Act 1972 as a conduit pipe. So the idea was it was the pipe through which European law entered the jurisdiction of England and Wales. And there was a question about, effectively, in the wake of the Brexit vote, whether that conduit pipe was going to be blocked and how that was going to be done. That takes us to the European Union Withdrawal Act, as amended, re-amended, re-re-amended, re-re-re-amended. It was chopped and changed a lot because of, obviously, all those things that we now look back on in fondness before the pandemic, things like hard Brexit and soft Brexit and all this sort of stuff. And the Act was chopping and changing quite a lot. What it ended up by doing is by announcing Exit Day. Do we all remember Exit Day on the 31st of January 2020, where nothing at all happened? And the reason nothing at all happened is effectively the implementation period that was imposed by the Act essentially held the position until midnight on New Year's Eve 2020 into 2021. That became Implementation Completion Day, or IP Completion Day, a suitable acronym for this audience. And that, as you may remember, involved the Act effectively taking a snapshot at that point in time, New Year's Eve 2020, of the current state of EU law in England and Wales. It repealed the European Communities Act, the original Act from the 70s, and effectively it moved the legal conduit pipe from the 1972 Act to the 2018 Act, and it gave powers, quite limited powers, for Parliament to start amending those laws that now became retained EU law, and for courts to do so. And here we are, we've got Lord Justice Arnold with us, and he's done the two leading cases on it. So in Tune In, I will simply say, he can speak for himself, but I will simply say that the decision was made not to depart from a settled line of Court of Justice cases on the meaning of communication to the public in the context of copyright. And very recently, in the ICE case, the decision was made to move away from a CG Court of Justice decision, effectively, principally, because there was another line in the General Court and other associated courts that was adopted as being a more appropriate approach. But this was a power based upon the power of the Supreme Court to depart from its own decisions, which was quoted by Lord Justice Arnold in ICE, paragraph 81, to say it's a power to be exercised with great caution. And there is a balance, as shown by those cases, between legal certainty on one hand and a rule impeding legal development, which takes us to the Act and its statutory purpose. I'm not going to whip through all of those, but I'm a big fan of explanatory notes. It'd be interesting to hear Ruth's view of explanatory notes, because they are a very helpful tool in statutory interpretation, because they tell you what Parliament thought a provision meant as it was making its way through Parliament, if, in the light of Ruth's talk, they thought about it at all. The key thing is it's a list of things that the Act is doing. It's quite an unusual explanatory note, because it says at the start, this is the purpose of the Act. And that's to stop we pesky judges telling Parliament what we thought the purpose of the Act was. The explanatory notes have told us what the purpose of the Act was. And the key thing is obviously removing a list of fairly obsolete old bits of legislation. But the key to it is the removal of the principle of supremacy, and I'll come on to that in a minute. I'm going to unpack two or three elements of the structure and architecture of the Act now. A couple of them have already been covered by Ruth, so I can take them pretty quickly. The first is the sunset clause, which Ruth talked about, and that's the point where it changed. It flipped from all EU law will go at the end of 2023 to some EU law will go at the end of 2023. And actually, if you look at the schedule, it's about 600 pieces of fairly obsolete legislation. And so, so someone described it, it turned from a sovereignty bonfire into an overdue spring clean, which was probably not the original intention. So, for example, we said goodbye to the Artists' Resale Right Amendment Regulations 2009, but we've still got the Artists' Resale Right Regulations 2006. So we are talking about generically fairly tidying up changes, generally, certainly in the context of IP and indeed in most contexts. But that will change. I mean, this is the point that Ruth made a minute ago with the dashboard of the 6-monthly reporting. More and more provisions will be added to the list, not of that clause, because that's a sunsetting clause, but the clause I'll come to in a minute. Retained EU law, this new concept that we had just got our heads round, has become assimilated law, which is slightly Star Trek-y, I think. But it's the idea that it's not EU law anymore. We've assimilated it, so it's British. So it's the equivalent of sort of stamping it with a Union Jack, I suppose. It's the mechanism, and Ruth again has touched on this already, I've summarised in three different, it does three different things. As well as renaming current law that hasn't been sunsetted in the first clause as assimilated law, it effectively makes it easier to change, tweak, amend, remove that law. The first way it does it is powers of restatement in sections 11 through 13. That is the idea that if they like a bit of legislation, but they want to de-Europe it, then they can restate it in different terms, tidy up anomalies, clarify things. It's a tidying up mechanism for keeping the sort of policy behind a particular piece of legislation, but tidying it up a bit. The second is relaxation under sections 9 to 10. What that means is, under the 2018 Act, as amended, other pieces of primary legislation were restricted from amending retained EU law, because the idea was everything was supposed to go through the filter of the 2018 Act. That relaxation has made it easier for Parliament in other acts to change what is now assimilated law. So it doesn't all have to go through the same funnel, as it were. And then there are these powers that Ruth has mentioned, of revocation, replacement, and repeal, which are beefed up. So in sections 14 to 16 of REULA, particularly section 14, the power to revoke and replace secondary assimilated law. So secondary assimilated law is basically assimilated law, so retained EU law, if you like, that isn't primary legislation. Or if it's in primary legislation, it was put there by secondary legislation. So, I said that the most important part was dismantling supremacy. Sorry if that's a bit of a small slide, but I'll whip through it. So, what is EU law supremacy? Well, it's the fact-attained decision. It's the idea that European law trumps domestic law. And that gives rise to a number of different tools in relation to EU law. So, you can have a situation like in fact-attain where a piece of legislation is disapplied, and there are lots of other examples of that having been done. You have a situation where direct EU legislation, what's called EU regulations, and treaty provisions are what's called directly applicable, which means that they have the force of law automatically without being coming through a domestic vehicle like regulations. You have direct effect, which is, as you probably know, in the old days, a form of European legislation called a directive would set out the parameters for a particular subject, and individual countries would then have a period of time to implement that through their own legislation, which had to follow the sort of bare bones, the skeleton of that directive. But there was a series of cases in the European Court which decided that, as against the public sector, defendant, you could just ignore the domestic regulation and just rely on the directive. That's called direct effect. And then indirect effect was that interpretative process of effectively bending domestic legislation that was intended to implement European law, but by expanding the language, contracting the language much more than you would do normally in statutory interpretation. All gone. That's what has changed. It's all gone. So you don't have indirect effect anymore. In fact, you have this intriguing provision in section 3, which I think is in force. I'll come to section 6 in a minute, which inserts into the 2018 Act, for some reason best known to somebody, what's called domestic supremacy. So that means any provision of assimilated direct EU legislation, so that's something which, a piece of legislation which was made in Europe that used to apply automatically here, it's now been assimilated. It must, as far as possible, be read and given effect in a way which is compatible with all domestic enactments. So it turns it on its head. Effectively, rather than domestic enactments being stretched or contracted to fit EU law, you now have EU origin legislation being stretched or contracted to fit domestic law. So that's a completely new thing, and it's something which doesn't really have any precedent at all. And there is one possible mechanism on statutory interpretation which is very different from indirect effect, but which may have some sort of transitional role, which is the idea talked about in a case called Brent LBC and Risk Management Partners, which I think Nina's going to pick up on in relation to a case called e-accounting that I did, but I'm not going to talk about that. That you can effectively say, well, okay, we don't have indirect effect anymore. We can't stretch language to the extent that we used to. What we can do is to say, this piece of legislation that I am interpreting was intended to interpret a directive. So I'm going to look at the directive and see what the directive says. And I'm going to take that into account as background. No more than that. Can't stretch the language, can't contract the language. But you can take it into account as background, and that is something which operates under ordinary principles of statutory interpretation and therefore might apply here. Section 6 is not in force yet, Lord Justice Arnold says. There is already a provision, as typified by Justice Arnold's tune-in and ICE cases, where the court, a relevant court, Court of Appeal, Supreme Court, can depart from retained case law. When Section 6 comes in, and there's every reason to think it will, that it amends that power effectively to give a bit more of a steer to domestic courts to encourage them to depart from EU law. That's the purpose of that. For example, it must remind itself that decisions of a foreign court are not, unless otherwise provided, binding. So judges will have to remind themselves of that and the other factors you can see in the top bit. The bottom bit is more radical still, because that is a statutory incursion into precedent. It effectively says that courts can basically not follow normal precedent rules and have to follow this rule in those particular circumstances, or but bearing in mind those factors. And if that, so effectively a Parliament telling courts there is a new rule on precedent seems quite radical. Well, references are even more, because they will create a situation where there are two points. The first is that it creates a mechanism for a lower court to refer, not be appealed to a higher court, but to refer itself a point of law, a bit like a leapfrog appeal, where the High Court can leapfrog to the Supreme Court. Well, lower courts can effectively refer in those circumstances on the slide, and the higher court can decide whether or not it's going to bite, whether or not it's going to consider the point that's been referred up. But Section 6b, let's say the government is reading the newspaper and sees a case where a point of European law comes up. And let's say the government think that a particular argument should have been run in that case about European law that's nothing to do with the government. Well, they can make a reference. They can effectively jump in, pick a point of law that arose in a case and make a reference to the higher court, Court of Appeal, which they must consider. That's going to be very interesting to see what happens with that. I doubt it's going to be very often used. It will go through the Attorney General, so there will be a filter in terms of legal analysis about whether it's appropriate to use it. But it is it's a very radical power indeed. So, faced with all of this, and this is where I finish, the end of EU law supremacy, new domestic supremacy over assimilated legislation, new rules of precedent, and new court processes. As Lord Wright said almost 100 years ago, judges will proceed from case to case like the ancient Mediterranean mariners, hugging the coast from point to point and avoiding the dangers of the open sea of system and science. Thank you very much indeed.
So thank you, Jim. Just one small footnote to that, which is that the power to make references to which Jim referred applies not just to courts but tribunals as well, and that of course includes UK IPO, which is why we wanted them here, because they are busy trying to formulate some policy as to what on earth they're going to do, because they're particularly think about some litigants in person in UK IPO who say, "What a reference, please." So they're going to be faced with that little conundrum. So, over to Nina.
Okay, good evening, everybody. I'm going to be discussing the impact of REULA's interpretive regime in relation to IP, focusing in particular on a couple of aspects of substantive trademark and copyright law. I'm then going to pass on to Philip, who's going to continue this theme. I want to start with some preliminary points. We've heard both from Ruth and from Jim about the revocation schedule that was attached to REULA. It had 587 pieces in it. Ultimately, that included only 7 redundant IP laws. So I think we cannot dwell on those any further, that there's no reason to do so, that they're redundant, that they're superseded. Otherwise, current IP policy positions have been maintained, though the government has so far made 2 SIs relating to IP using some of the powers we've heard about under REULA. Philip is going to touch on one of these, which is the very difficult, intractable subject of exhaustion. The other SI makes certain technical changes to legislation relating to design rights, semiconductor topographies, artist resale rights, address for service at the Copyright Tribunal, and also auditing of CMOs. So if those points are of interest, I suggest you look at those regulations. Otherwise, the UK IPO has not yet used powers under the Act to codify existing IP case law, but it has said that it will be monitoring for any signs of divergence or impact on legal certainty. And of course, that is our focus tonight. What is the outlook for EU-derived domestic IP legislation and the related body of case law, both CJAU and domestic, that is built up around it as we really start in earnest to disentangle ourselves from the EU legal framework. So as we just heard, REULA has removed various interpretive effects of EU law. So in particular, supremacy of EU law, including the Marleasing principle of indirect effect, the duty of consistent interpretation, that has now gone. That said, it's important just to note that REULA removes these principles in relation to anything that is occurring from the 1st of January 2024. That's because Section 22.5 of REULA tells us that it still applies EU law supremacy and Marleasing to anything occurring before that date. So what does all this mean for our approach to EU-derived domestic IP legislation going forward? So, as we know, much of our domestic IP law derives from EU legislation and from conforming interpretations of that legislation by reference to CJEU case law. When you remove the keystone in that framework, so supremacy of EU law, indirect effect, where does that leave the existing body of precedent that has built up around it? And I'm going to refer you here to, I hope I'm not going to make you blush, Philip, your excellent article in the EIPR on REULA and IP. And Philip says in that article, are we going to start seeing domestic case law flapping in a wind of uncertainty? So we had, of course, become very used to IP cases being argued directly by reference to the EU legislation. So, as Mr. Justice Jacob, as he then was, said in Treat, what mattered at that time was the language of the directive, as Parliament's intention was to implement whatever the directive meant. And we've just heard also some of the comments that he also made in the Intel and CPM case. But under REULA, we, the courts, can no longer go straight to the wording of the directive. And where courts did this in the past, we are going to need to look at the domestic statutory language afresh. So, we already have a decision that can give us some guidance here. This is the e-accounting and global emphasis decision from last year, where His Honour Judge Tyndall made some important observations about the potential impact of REULA. So these were obiter, as it was agreed that the regime as then set out in the EU Withdrawal Act, so at that point still incorporating supremacy of EU law and marleasing, because this was to do with unamended pre-Brexit legislation, that existing regime continued to apply. So to the extent then that the court considered the potential impact of REULA in this case, we can see this as a kind of worked example of the potential change in interpretive effects. So this was a keyword advertising case. There were claims under sections 10.1, 10.2, 10.3 of the Trademarks Act, and also for passing off in relation to the defendant's use of the sign advance track, both as a keyword and also within the ad text itself. And both the keyword use and the use in the ads were found to be infringing and also passing off. And as I've said, the court reached this outcome by applying marleasing, the retained EU case law and the domestic case law. So this comprised CJEU case law such as Arsenal, where it was confirmed that there was no infringement under Article 5.1a of the directive, unless there was an adverse effect on the functions of the trademark, particularly the origin function, even though there was no specific wording to that effect in the directive or the EU trademark regulation. It included L'Oréal and Belleur, where the court identified other functions of the trademark that could be adversely impacted. And of course, it included the test in relation to keyword use in Google France, later elaborated on in Interflora and Marks and Spencer. But His Honour Judge Tyndall said it would be unsatisfactory and lead to uncertainty if the analysis stopped there. And that was because REULA was about to bring these seismic changes to EU-derived domestic legislation and the relationship between assimilated law, as we must now call it, and EU law. In effect, we could no longer employ our old interpretive ways. However, whilst under REULA indirect effect was to be no longer part of our law, this did not mean, I'm going to unpack some of what Jim was just introducing, EU law would become irrelevant. It did not mean that. So specifically, where domestic legislation, and here it's obviously the Trademarks Act, had been enacted to implement a directive, so Section 10 of the Act had been amended in 2019 to implement Article 10 of the recast Trademarks Directive and hadn't been amended subsequently, that would be relevant context in interpreting the Trademarks Act on orthodox domestic statutory interpretation principles, whilst recognising, however, that the statutory words would always be paramount. So, focusing on the paramount statutory wording in Section 10 then, as amended in 2019, in all important respects, the language was effectively the same as in the recast directive. So one would therefore expect it to mean the same thing, and the obvious conclusion was that Parliament intended it to do so, and it had ensured that by amending the Act rather than relying on indirect effect. And that was clear on both a consideration of the paramount statutory language itself and also from a consideration of the external aids. So the court said, therefore, there would be infringement under a REULA approach in relation to the ad text under section 10.2 and 10.3, and also in relation to the keyword use under section 10.2 on ordinary principles of statutory interpretation without any recourse to external aids. However, this did require some further analysis of the keyword use claim under section 10.1. That subsection does not, of course, state the relevant use must adversely affect the functions of the trademark. That was a gloss that was introduced and developed by the CJAU. It's also not there in the wording of section 10.2 and 10.3, but it is at least intrinsic or implicit within the requirements of those subsections. And so here, this is where a purposive interpretation echoing the approach in Brent could come in. So section 10.1 in 2019 was plainly intended to implement the recast directive, which was intended to mean what the CJU had interpreted it to mean, i.e. including the gloss of adverse effect. The conclusion was it could not have been Parliament's intention or purpose to make something unlawful which had no adverse effect whatsoever on a trademark. So, if REULA was in effect, the conclusion would have been the same under this approach, even once the interpretive effects of REULA were removed, of EU law, were removed. So what I think this demonstrates very neatly as a worked example is that whilst EU law is no longer supreme and an indirect effect no longer applies, EU legislation, the body of case law, both CJU and domestic, that is built up around it, it's clearly still going to continue to play a role in the interpretation of EU-derived domestic IP legislation. But, as His Honour Judge Tyndall said, this is a very, very long way indeed from EU law supremacy and indirect effect. I'm going to turn to copyright now. Now, there's a number of examples of potential divergence that could be given here, and I'll refer you again to Philip's article because he highlights a number of them. But I'm going to focus on the tension between the UK and EU approach to what can be protected as a copyright work. So, Section 1.1 of the CDPA, it is clear and unambiguous. Copyright protects a closed list of categories of works. But, as we all know, a series of CJU cases, so Infopac and its progeny, more recently Levola, Cofamel, Brompton, they have led to the view that the closed list approach does not conform, under Marleasing, with Article 2 of the Information Society Directive as interpreted by the CJU. So that approach simply requires that the subject matter must be original, in the sense of the author's own intellectual creation, and it must be sufficiently identifiable. So you may remember the Response Clothing case from 2020, I think. So His Honour Judge Hakon sought to interpret Section 4 of the CDPA, and that was a case concerning whether a particular fabric, a jacquard fabric, constituted a work of artistic craftsmanship, and he sought to interpret Section 4 so far as possible in conformity with the approach in Levola and Cofamel. But he did point out that the complete conformity with Article 2, as interpreted in Cofamel, would exclude any requirement that the work had to have aesthetic appeal in order to be protected. And meanwhile, we are, of course, waiting for the decision in Water Rower as to whether a water rowing machine is protected as a work of artistic craftsmanship under the CDPA and or by applying the EU approach. The defendants sought summary judgments to strike out the claim in 2022. That was unsuccessful. The Deputy High Court judge in that case, David Stone, said, well, look, at this stage, we do not need to resolve this conflict between the CDPA's closed list and the EU approach. But he was clear in his view that this was an issue that would need resolving at some stage, either by Parliament or by the higher courts. And the issue here, of course, is that a work might satisfy the EU Livola COFMEL test, but fall outside the CDPA's closed list as traditionally construed. If we accept that applying marleasing required a more expansive interpretation of the categories in the CDPA, where do things stand under REULA now that marleasing no longer applies? Does it depend, for example, upon when the work was created, given the impact of section 22.5, as I just mentioned? I also want to mention the related point of originality. Section 11A of the CDPA requires authorial works to be original. As you will remember, I'm sure, the traditional UK test required the author to show the necessary skill, labour or judgment. The EU test requires the work to be the author's own intellectual creation. So we know that the author must make free and creative choices and stamp the work with their personal touch. If there was any doubt as to the correct approach to originality under a marleasing interpretation and whether the EU test had raised the bar, these were removed by the Court of Appeal in THI in Sheridan in November last year. So this case concerned a graphical user interface with fairly limited visual creativity. The EU test was not put before the judge at first instance, and this went on appeal. And as Lord Justice Arnold stressed, the two originality tests are not the same. The EU test is more demanding, though it was an objective test with no requirement of artistic merit. Now, despite this higher hurdle, the Court of Appeal did still find that graphical user interface was protected on the EU test, albeit its scope of protection was found to be narrow. So again, there's going to be potential question marks around how REULA could impact on the approach to the assessment of originality in future cases. So just a few concluding sort of thoughts before I pass over to Philip. I mean, I think it does seem that if divergence is going to come, it is going to still come fairly gradually. It's likely that, at least in the short term, many outcomes will be no different under REULA. The legislation is often clear enough on its face, or the existing interpretations could be reached through domestic principles of construction, which recognise the context in which the legislation was made. And even beyond that, where the court isn't bound to come to a particular conclusion, having considered the legislation, it's not as if REULA compels the court to reach a different conclusion to that taken in the EU. However, some situations may be decided differently. By changing the relationship between domestic legislation and the EU legislation that it was intended to implement, coupled with the courts being given more of a nudge, a steer, an encouragement to depart from CJU case law, it's clear that REULA has introduced a significant element of uncertainty. And identifying where those fault lines will lie in advance is likely to be tricky. So I think whilst the impacts of REULA will take some time to come through overall, it may be that we find that some individual cases bring quick and significant changes, and those may force us to reconsider the stability of parts of our IP landscape. Thank you.
So, thank you, Nina. And lastly, we have Philip.
I'm left with the odds and the ends, the bits that other people haven't discussed so far. So these cover things like exhaustion, issues about references from the appointed person, trade secrets, enforcement and so on. To start with, we can look at exhaustion. Exhaustion was retained in an asymmetric form following IP implementation days. So in other words, we treat exhaustion as it used to be treated under EU law. The EU doesn't count us as a relevant country for putting it on the market. Now, because of the way those regulations were drafted, the original version relied on the idea of things which are retained rights under the treaties, which were retained originally in section 4 of the 2018 Act. That didn't work anymore once that was repealed. And so they made new regulations which largely have the same effect, or intended to have the same effect. Now, there's a couple of things to notice about these. The first is they talk about putting things on the market, which isn't that conventional, but they say anything which may be lawfully imported into the United Kingdom by virtue of anything which forms part of assimilated law as a result of Section 3 of the Act. Now, that's direct EU law. Now, I'm not entirely sure what that's referring to. It may be referring to the border regulation, but I'm not entirely sure. If it were referring to that, they might have referred to that, but they didn't. So it may be that, otherwise it might be something they've spotted I haven't. The other change is they've introduced a new provision for patents. Now, patents has never had its own exhaustion provision. It had one originally in the Act, but it was never brought into force. And so we've always relied, and this is why the provision, which was cause of problems in the original 2019 regulations, the original provision relied simply on direct EU treaty provisions. But they've now introduced a statutory provision, Section 63A. But they've introduced a new oddity, which seems to come from trademarks, which is you can have a legitimate reason to oppose the placing on the market of a resold patented good. Now, that seems to be new to me, but it is there. It's a novelty we face. Now, moving away from exhaustion, which isn't that exciting, except that the EIPO has been consulted and probably will consult on again about what they want to do in the future. At the moment, we're retaining the provision. We move to the Enforcement Directive. Now, the Enforcement Directive was originally implemented in 2006, and back then the view was taken that little was needed to be done. Now, I say the view was taken, I should take some personal responsibility for this, because I was the IPO lawyer at the time, and I implemented the directive. So when the view was taken, it was largely a view I very strongly shared. We didn't need to do very much. The view was that most of the remedies that were set out in the Enforcement Directive were things which were already recognised in the English courts, at least. Some changes were made for the Scots courts, but for the English courts, we only made a change to recognise damages and to allow publication by a change to the CPR. Now, even the CPR change probably wasn't needed following Apple and Samsung, but initially it was very little, very light touch indeed. This left certain things we didn't implement. 2 examples, there are others, but 2 examples of proportionality. There's a requirement for proportionality in the directive to ensure that remedies are effective, proportionate and dissuasive. And that's been cited by the courts many times. There was also search orders seem to have particular wording which we didn't directly implement but were referred to in the directive itself. So, for example, a search order, what we used to call an Anton Pillar order, is available when, according to the directive, when reasonably available evidence support is there. Whereas we, of course, have a prima facie case. Are they the same thing? Never been tested. It applies to relevant evidence for the case rather than major evidence or evidence of critical importance. Again, never been tested. Is that the same thing? Do we have something where the courts would have to have moved? Now, before we left the EU, those were points which could have been taken, but as far as I'm aware, never have been. Which brings us on to the Trade Cooperation Agreement. Now, one thing to be aware of is the EU, when it made its free trade agreements, included lots and lots of directive provisions with its free trade agreements with third countries. The most significant one is actually with Ukraine. Ukraine has masses of provisions with the EU agreeing intellectual property standards. Now, when we rolled those over, we kept all those standards. So we have lots and lots of treaty provisions with, under free trade agreements which largely reflect the text of a directive. Now, I'll come on to that in a moment, but we also have the Trade and Cooperation Agreement, which has got a higher status than others for reasons I'll explain. And this includes in Article 256 that remedies have to be effective, proportionate and dissuasive. And in Article 258 we have very similar wording to the wording of Article 7, and it refers to reasonably available evidence and preserve relevant evidence. So in other words, the powers are there which were once in the directive. So while we didn't implement much of the Enforcement Directive, most of it is now in the, or when I say most of the key provisions, some of the additional bits aren't. Most of the key provisions are in the Trade and Cooperation Agreement. The Trade and Cooperation Agreement is something which has a general implementation. What this means is that all that text of the agreement is essentially text of our law. It's a bit like direct effect and direct applicability, but isn't, because of course you don't have such things anymore. But it says, as the Court of Appeal in the Heathrow Airport case It said it's a blanket generic mechanism to achieve full implementation without the need for any further parliamentary or executive intervention. So domestic law and issue is what it says in the TCA. So going back to that, this is now our law. Our law reflects Article 256 and Article 258, and I don't see any reason in principle why it can't be relied upon to some degree, if not absolutely, within the courts. Which means when we didn't implement things back in 2006, then they are now effectively statutorily implemented for most of the aspects of the Enforcement Directive through the TCA itself. Now, if you're interested in this sort of thing, I wrote a book a couple of years ago looking at all the free trade agreements we'd entered into at that time. There's been a couple since, and set out all the different comparisons between directives and regulations and what's in these free trade agreements. And there were very, very few things the EU hadn't spun out in at least one free trade agreement, in which we had rolled over in our desire to have free trade agreements with absolutely everyone we could. So many of the EU obligations are actually, through directives, are actually international law obligations. Now that can be relevant for the reason that Judge Tyndall said, is that these are legitimate interpretive aids. International law is something we use to interpret our laws, and of course we have a rule we don't, as far as possible, interpret domestic law in a way which is incompatible with international law. So one can turn to treaties and use those as a guide towards what the law may or may not mean. And of course the background to those treaties was attempting to harmonise EU law with these other countries, to bring these other countries to EU standards, particularly countries like Ukraine, which when the agreement was signed was there to enable accession. So there's that sort of background to this as well, which brings us to trade secrets. The Trade Secrets Directive is a little more complicated on this point. The Trade Secrets Directive was implemented in 2018, long after my time. But the view was taken that the provisions as to remedies and enforcement did need statutory interpretation. But Articles 2 to 5, which were the more substantive provisions setting out what a trade secret was and the scope of the trade secret rights, didn't need implementation. The view was taken, the directive is a minimum standards directive, which is right, but it didn't actually require implementation because breach of confidence went further. Now, in most respects, that's probably true. But as with all things, there are a few things floating around where it may not be. One example would be derivative products. Under the directive, goods which significantly benefit from unlawfully acquired trade secrets are unlawful. It's unclear whether that would be unlawful under breach of confidence, whether goods derived from a breach of confidence are in themselves unlawful. It might be, it might not be. Now, unlike enforcement, the TCA doesn't have any provision on derivative products. In fact, trade secrets aren't very well covered in free trade agreements at all because there's quite late harmonisation in EU terms. Another example is reverse engineering. Now, reverse engineering is referred to in Article 3 of the directive, and those who know their trade secrets will be aware of the Mars and Technology case and the more recent Volkswagen case, which seems to make reverse engineering lawful sometimes. And the TCA here in Article 252b allows but doesn't require reverse engineering. So again, it can't be used as an enforceable right because it's just permission. So here with trade secrets, there's much more ambiguity about how to take this forward. If you don't have leasing, if you don't have these rules, how much does the Trade Secrets Directive remain relevant? In some respects, you have express terms and things like the remedies and enforcement are set out. But in terms of the actual substantive law, very, very little is in the implementing regulations. So it may well be that the directive has little or no effect going forward, in contrast to many other aspects of EU law. Now, this takes me to one of the masterful things that was done in the Act. As you've heard from Ruth, this was an Act which they thought about for many hours, they contemplated, they took, they went away, they thought, which laws are the ones we want to keep, what effect will that have, how will that make lawyers feel, how will that make society feel? And they came up with the idea of references. Now, references are so that any court or tribunal can make a reference. And as Richard has said a moment ago, the IPO has to consider whether it can make references, because it can make references. The IPO is a tribunal which has an appellate court above it, so therefore it can make a reference to the Court of Appeal, because from the Intellectual Property Office and trademark patents and indeed design matters, the appeal is either to except for patents, it's either to the appointed person or the High Court. If you go through the High Court, of course, you can go to the Court of Appeal. so therefore the Court of Appeal is an appropriate higher court. On the other hand, the appointed people, you cannot appeal from. There is no right to appeal from the appointed person. And I'm not sure if this is unique. Most tribunals have traditionally had appeals on points of law from the highest tribunal to the Court of Appeal. The appointed people don't. Appointed person doesn't. Sorry, we're not plural. We are plural, but we're not plural. And so it's not quite clear. The Act is drafted so that a reference can be made to the Supreme Court from any tribunal or court, but it can only be made if it's retained case law of the Supreme Court. If it's retained case law, simulated case law, I've used the language of the Act here rather than the language you should now use. It is no longer retained, it's simulated. But if it's a simulated case law of the Court of Appeals, in other words, the Court of Appeals adopted a decision of the Court of Justice, that is something where a reference cannot be made from the appointed person, but which brings us to a very strange situation. That you can make a reference from the registry, but you can't make one from appeal from the registry. So if you want to appeal, you have to go to the High Court. Now, the reality is, of course, if you go before the appointed person and say, this is something we want to make a reference on, what you'd probably do is make an application to transfer the matter to the High Court and then allow the High Court to do it. But leaving appointed people for aside for a moment, bearing in mind, if one looks to the High Court, is there much of a need for this within the High Court's sphere? Of course not, because there's the Administration of Justice Act, which has allowed leapfrog appeals since whenever the 1969 Act came into force. But that has been used so sparingly. It's been used 19 times since the Supreme Court came into being in 2009. There are other points to bear in mind is if one looks at the very, very limited grounds which a reference can be made for the appointed person on the grounds that it can be a Supreme Court decision, having looked at them, there is one designs case where you might get something out of, but almost all of the trademark cases relate to things like exhaustion and criminal infringement. It might be you could spin something on Johnson, but I'm not entirely sure, which means the reference procedure isn't likely to have impact at this level, but it probably will below, which it may make sense, but it does seem slightly incongruous. I'll finish with patents. Now, patents are not something which has had very much harmonisation at EU level before the unitary patent, which of course never applied here anyway, so it doesn't really matter. Now, the one example of a directive is the Biotech Directive. Now, this was implemented in the Patents Act in Schedule A1 and A2. But significantly, the European Patent Convention, not a member of the European Union, not connected to the European Union at this point, included a rule whereby applications concerning biotech inventions, the convention should be applied and interpreted in accordance with the directive. So it actually linked the directive through to the European Patent Convention and allowed interpretations of Court of Justice decisions to be taken into account. So that means the Biotech Directive may come through, and decisions of the Biotech Directive may come through here by reason of Section 130, subsection 7 of the Patents Act, which I'm sure everyone talks about over tea every evening. It's one of my favourite provisions, I have to say. I wrote an article on it, with my favourite article type I've ever written, Mr. Skemp's preposterous provision. Mr. Skemp was the drafter of the Act, and one of the things, we've talked about explanatory notes, one of the great things about old Acts is Parliamentary Council's papers. Once the 30-year rule has passed, you can look at Parliamentary Council's papers and you can see why they came up with some of the odd things they did. And it's one of the most fascinating things to find out. Things that you thought were no issue at all, they spent hundreds of pages discussing. And things that you think are really significant, they didn't look at all. And it's so, but anyway, Section 130, subsection 7 says that certain provisions, and not all provisions, but certain provisions of the Patents Act should be interpreted in conformity with the European Patent Convention and the Community Patent Convention and the Patent Cooperation Treaty. And this has been the basis of the reason that the English courts look to Board of Appeal decisions and so on. Now, it was expressly mentioned in Merrill Dow that the case, but since then it's largely been taken as read without going back to Section 130, subsection 7. But it's not entirely clear when one moves away from listed provisions. Now, because biotech would be to do with patentability, and patentability is listed, then it probably doesn't make much difference unless one's talking about legal deposit. Legal deposit probably may fall under patentability, may not. But the other sections, there's a divergent view to whether one can use and look directly to Board of Appeal decisions. In the Kieran Amjem case, the view was taken that you should use a normal rule for interpretation of international treaties, and whereas I think Mr. Justice Arnold, I think it was you, and in the Laboratories case, where you looked at the role of abstracts on the EPO and took the rule that we could just look at the cases there, although abstracts were not relevant to a listed provision because they were procedural. So there is some patents may still come through an indirect route, although the reality is there isn't very much there. So with that, I've sort of gone through everything else left over, and I think that leaves questions for us all.
So, thank you, Philip. Yes, we've got just a few minutes left for questions, and as Chair, I'm going to exercise Chair's prerogative by getting the ball rolling by asking Ruth a quick question, since we have an expert on parliamentary procedure here. Clause 27 of the Finance Bill 2024, which currently is at its report stage in the House of Commons, does something which, in the light of what you've heard this evening, is a little extraordinary. Namely, it partially reverses REULA so far as VAT law is concerned. Oh yes, you might have thought that REULA was the end of the story. Oh no, it's not. And one asks oneself, well, why? And the answer, of course, is to think about why all this is happening in the first place. If you wind back to the EU Withdrawal Act 2018, the point there was, yes, we'd taken back control. We'd reinstated parliamentary sovereignty, so Parliament could do whatever it liked. But until Parliament did something, the principle applied in the 2018 Act was continuity of the law. The whole point of REULA is to say continuity of the law is too much of a constraint. So we're going to liberalise, and we're going to liberalise in two ways. First of all, as Ruth was explaining, we will allow the executive to change the law without Parliament through the device of the SI, or with very little parliamentary scrutiny anyway. So that's liberalisation mechanism number one. Liberalisation mechanism number two is to give judges like me greater power to depart from EU law through the ways that you've heard. And obviously, as a judge, one likes to have the ability to come up with the right answer. But on the other hand, the downside is, as you've heard, greater uncertainty. So, why is it that the government is now reversing REULA for VAT law? Answer, because I think they realise that the VAT system being entirely EU dependent, the whole concept of VAT comes from EU law. I think they've realised that it's going to cause chaos if you apply REULA to VAT law. And that's why they're unwinding it in the Finance Bill. So, question to Ruth. Given,
I'm not an expert on VAT.
of course not. But my question is this. If the government is thinking again with regard to VAT, might they think again with regard to other areas of law?
Yeah, I mean, that's a political and a policy question. Yes, they may well. And of course, a different government may take an entirely different approach anyway, because if we are to have a new government towards the end of the year, we will, if the polls are true, we will likely have a government that wasn't enamoured with this approach to rule reform anyway, and isn't necessarily looking for the degree of divergence that the current government wants. I think it's entirely possible that we will see over the years, as they discover technical problems with divergence or with the way in which they've approached some of these policy changes, that you'll see other acts of parliament where they do unwind things. Because the interesting thing is the degree to which politically there is understanding of that within Parliament. In the legal community, where you're looking at areas sector by sector and you have to get into the technical detail of it, there'll be much broader understanding. At a political level, we could be looking at a new Parliament in which 25% or considerably more of the MPs will be new. They will have very little past institutional knowledge of what's happened with this legislation at the beginning of the process, when they first started out in the whole debate about revocation, very little knowledge of what's happened in the interim, what's happened with areas like financial services, for example, whether the whole set of other scrutiny provisions underway in Parliament for looking at regulations in that sector in relation to retained EU law or assimilated law. And we will have a new Parliament in which knowledge levels are lower and in which this may not be the kind of political priority it has been for this government.
So once again, we learn that Brexit is not an event, it's a process, and quite a long one. Right, question from the audience. Stunned silence. Yes.
Hi. Am I on? Yeah. My name's Vicky Salmon. I'm at Impact IP. We had a whole load of legislation in the schedules, IP legislation in the schedules for the Brexit deal. Do they restrict what Parliament can now do under the REULA in terms of changing IP law?
Philip.
Do you mean the schedules for the Northern Ireland Agreement, or do you mean the schedules to the...
Weren't there a load of schedules at the back of the Brexit legislation about certain...
Which one?
Oh, there was a whole big one on...
There's lots and lots of schedules. I wasn't aware that there was IP legislation listed there. That there was lots of amendments made to retained EU law, assimilated law. Sorry, it's now one of us. But I'm not sure that I know that there was in the Northern Ireland Agreement there were certain things which continue to apply, such as the border regulation and things like that were applied in modified form. They will cause problems. Because of course, but then the issues and difficulties that the leaving of the EU has caused in relation to Northern Ireland are well known, and so that I think it's part of that. I don't think that will affect, because I mean they've in lots of things they've divided out in regulations. They've got different regimes for Northern Ireland and Great Britain. So SPCs, for example, they've got different regimes of marketing authorisations from Northern Ireland and Great Britain. So that there'll be restrictions on what they can do in relation to Northern Ireland, but not in relation to Great Britain. As far as I'm aware, and that might be something I'm just totally unaware of, but as far as I'm aware, I don't think there is.
And that aspect in relation to Northern Ireland was part of the problem, I think, with exhaustion, wasn't it?
Yeah.
In terms of why they were faced with the situation.
Yeah, I mean, Northern Ireland possesses, because it's part of the customs zone, it's also very problematic when it comes to exhaustion. So that's why they've come to the reasons they have so far, as I understand.
Yeah.
Thank you all to the panel. I'm Dr. Luke MacDonald from LSE. I'm really grateful to you for explaining what this is all about, because I was not really fully aware of what exactly was going on, and now I am. And it's one of the most extraordinary pieces of legislation I've ever encountered, I have to say. I mean, it's legislation as therapy. Thinking about this Brexit as a process rather than an event, I mean, when the 2018 Act did not have the effect that Rees-Mogg and Bill Cash and others sought, they think, oh, now that we can have this new act and that will have this titanic change to the law and will get rid of all of the virus of EU law, seems to be the idea here. But the effect of it, I wanted to ask James as a judge, and Richard, if you're able to comment as well, is the effect of it not just to make your job much more difficult as a judge? I mean, you're now, you have less freedom, it seems, to actually... Because now you're being told you're not allowed to look at that directive other than if you can sneak it in through your very clever interpretation, James. But you seem to have fewer tools to actually do the job that you're normally expected to do, or have I misunderstood?
Well, I'm interested in Lord Justice Arnold's answer.
I wouldn't see it that way myself. I think it does make life more complicated. But of course, one of the things you will appreciate is that it does depend to some extent on what arguments the parties bring before the court. Let me give you a simple example. Suppose you've got a case about likelihood of confusion in trademarks, where we've got a well-established test based on a lot of Court of Justice case law, summarised for domestic purposes in the standard list of principles that are trotted out in every case. And you're now talking about many thousands of them. Now, are parties really going to want to come to the court and say, throw all that out the window, please? We're going to start on arguing what the test is from likelihood of confusion from scratch? I don't think so. And if they do, I don't think that many judges are going to be terribly receptive to that. So, for basic stuff like that, I'd be pretty surprised if people are really going to be seeking to say that the law is somehow radically changed. But where you will get arguments coming up are on some of the more esoteric issues, and on some of the issues which have been identified where there were fault lines already. So Nina's example about copyright law, I think, is quite an interesting one, because we are faced with this situation where we have a closed list of subject matter which includes works of artistic craftsmanship. And in the 21st century, we're supposed to be applying that as a test. Our legislators not having seen fit to exercise their freedom to change that law. And that's been very difficult subject matter for the courts to get to grips with pre-EU. During the EU, it didn't get any easier, and we're still going to be faced with it after REULA. And so what you're going to get is an additional layer of arguments in cases like that, so additional complexity, and guess who's going to pay for that? Yes, over here.
This is just to add an additional layer to all that complexity. So if you have a directive which was not implemented in a literal way, so the implementation, I couldn't come up with an example during your talk, but I'm sure there will be. So the UK legislation actually does something with it, which was the essence of directives as EU legislative tools. They fill in the gaps, they make it a little bit more appropriate to the UK reality. There are differences between the EU directive and the wording and the national implementation. So wouldn't that be a situation where parties before your courts will argue, well, here EU law is completely irrelevant. You should not be actually interpreting our national legislation in light of what the directive was about, because that's out. Even if the case is that there is a long line of CJU cases arguing in that way.
Well, I think it's going to be a case-by-case situation, and it's very much going to depend on the particular legislation we're concerned with. But as a starting point, if you've got any piece of UK legislation, whether it's primary or secondary, which was originally intended to implement a directive, it's pretty hard to say that the directive is irrelevant as an aid to interpretation. Yes, you can say, and Parliament has said, supremacy goes, so we don't apply mar-leasing anymore. But it's another thing to say that it's irrelevant. Philip?
Isn't the point there that there's some directives where the view was taken at the time of implementation that the Act was already... So it's in the application, which is also covered by the 2018 Act, as well as the application. You didn't have to amend it. It could just be you've got a provision already applied. But the wording of it is such that it doesn't fit in any way. I mean, water is a good example. There's quite a few examples in copyright where the Act doesn't fit in any way with what the directive said or how it's being read now, compared to how it was, how the Act approach looks textually. And I think that is going to be a challenge, or at least it's worth a challenge if you've got a case where it helps you, which again limits it, because most of these things are quite esoteric. There's an example of one of the exceptions, for example, which doesn't apply to one of the works, but it was held to apply to a work, and there's things like that where. So I don't know. I think in trademarks it's not, and designs, because largely it's textually copied. I mean, across the law generally, one of the strange things is, when I was in government, there wasn't a view for copy-out was quite controversial. The idea of copying directives was not thought to be the appropriate thing to do. But by the time we left the EU, through the Conservative government in the 2010s, the government view came, you should copy out. So things which were implemented 20 years ago and before were not copy out. Things implemented 5 years ago tended to be copy out. And so actually it's older implemented directives which are more problematic rather than more recent ones.
Can I just pick up on one thing you said there? I think that there is a sort of nuance. I agree with Lord Justice Arnold that obviously depending on the cases, but directives will be relevant. But I think the argument that might be run by the party that doesn't want you to look at the directive is this point about we've moved from Lord Justice Jacobs' model of look at the directive, don't really worry about what the domestic legislation says, to a model where we must look at the domestic legislation, and it's the domestic words that matter, but we can look at the directive as a sort of contextual aid, and that's the modern approach to domestic statutory interpretation generally in a Supreme Court case last year, which is referred to in the notes. So, and that is, I think that's the difference. So you'll still have those arguments, and one party will try to say, just look at the legislation, but what they'll do is they'll downgrade the directive and say it doesn't matter anymore. Even if it's relevant, it doesn't affect.
So we are out of time. I'm afraid we can't take any more questions now, but you can continue the discussion over drinks. Please thank our speakers.